Hegde, let me start by asking you, because one of the questions that the Supreme Court is asking, perhaps you're best placed to answer that, sir, whether a petition by a political party on the issues raised is maintainable under Article 32. Now, the Attorney General had argued before the Supreme Court that political parties might claim to espouse public interest, but are actually seeking to score political points through the judicial machinery. Mr. Hegde, you're the counsel for the CPIM that's actually moved the Supreme Court in the demonetisation matter. How would you respond?
Well, that's an argument that the Attorney General has taken. The Supreme Court will no doubt deal with it in good time. But getting rid of one petition or one petitioner doesn't take the case anywhere, because there are a whole host of petitions where everybody is entitled to espouse the public interest, come to the court, and after all, the Supreme Court, in its own words, has been the court for the loneliest, the lost, and the last. So the CPM has decided to espouse the cause of people who cannot come to court. Whether they have necessary locus or not, it's a matter for the court to consider. There have been instances in the past where political parties have been heard, and there have been substantial judgments rendered by the court. We will no doubt, when our turn comes, answer all that in court. But this is just a technical argument. It may get rid of one petitioner. The larger questions remain, and they have to be answered by the Constitution bench.
Okay, it is a 5-judge Constitution bench that will hear the matter. But Mr. Bhattacharyya, you know, I think a large number of the questions, of the 9 questions that the Supreme Court has framed, pertain with whether the 8th of November notification is a violation of the Reserve Bank of India Act of 1934. The Supreme Court will investigate if under Section 26(2) of the RBI Act it has the necessary powers to initiate such a drive across various currency denominations and series. It will also look at whether this violates the right to equality as enshrined in Article 14 and fundamental rights under Article 19. You know, I want to get your comments first on the questions that the Supreme Court has framed today.
You see, Supreme Court has framed questions on a very comprehensive note. The prime question of the power of the Central Board of the Reserve Bank of India under Section 26 Clause 2 to recommend to the central government to cancel currencies of particular tender. That power is there. And today the scheme has been announced on 8th of November. It will last till 30th of December. So in my respectful submission, with due respect to all concerned, after 30th of December, this will be an academic question, because this demonetization step is an irreversible step. I mean, it can't be taken back. Practically, it can't be taken back. So therefore, if on the very, I could have understood if the petitioners had approached the court on 8th of November night itself, they have knocked the doors of the Supreme Court on that night, and then they had got a stay on the 9th night or 10th, I could have understood. But now, out of 50 days, when 36 days, 72% is already expired, 13 lakh crores of rupees have been plowed back to the... All these questions are very, very substantial questions of law. But in my view, these are, I mean, this may soon become only an academic question. Because, you see, the urgency in these matters are extremely important. This is a matter which affects 125 crores of people of the country. So, there's questions like Article 300A, whether right to property, whether it is a constitutional right, which is less than a fundamental right. Now, all these questions are surely important, and Supreme Court may well decide for or against. But one way or the other, at the end of the day, I don't see, in my respectful, humble submission, I am not a petitioner before the court, nor am I a respondent. I am just watching it from a distance. I don't think this will lead anywhere as far as demonetization process is concerned. The only concern for the government of India now should be...
Hang on, Mr. Bhattacharyya. Let me get Sanjay Hegde to respond to the comments that you make, because that's a valid argument as well, that this might end up being purely an academic exercise. Yes, it could perhaps set the precedent for future actions if the government were to consider demonetization in the future, but it doesn't really help remedy the past, Sanjay Hegde.
Well, that obviously the Supreme Court has factored that in, and as Mr. Bhattacharya rightly implies, it may be a case of operating after the patient is dead. But the point is that the Supreme Court is a constitutional court. It settles constitutional questions. Constitutional questions are not decided in a vacuum, but when the occasion arises. The occasion having arisen, the power having been used in that particular manner, even if it is a judgment which comes for the future, it's a good thing. At the same point of time, the validity of government action is being tested in a judicial forum. The process does take time, and the Supreme Court was not minded to act in a hurry and immediately stay things, because after all, a monumental decision which is taken by a government which is elected with a huge majority cannot and is not normally interdicted by the courts at the interim stage. What the final judgment is, that will of course await the hearings and the judgment writing later. I won't make I won't hazard any comments on that. But I don't think it is fair to say that the court did not give an interim order just because of the process. The court would have considered the extent of intervention that it could have done on the basis of past precedents. It has worked reasonably expeditiously, but expeditiously enough for some people, that is not possible.